It's Michael Popok with the Legal AF update. We got a new stipulation and order entered by Judge Engoron against Donald Trump and his bonding company, which gives additional security to the people of the state of New York to secure the $465 million bond. The very thing that Alina Habba, the lawyer for Donald Trump or whatever she is, likes to go on softball Newsmax and other right-wing echo chambers and say that the judge doesn't understand financial services, doesn't understand how money markets work, doesn't understand how collateral works. Nothing could be further from the truth. In fact, the judge Engoron properly shepherded the process through and obtained a number of major concessions that improved the amount of security and the type of security that Donald Trump is now required to have put up in order to stop enforcement of the $460 million or more civil judgment in the name of the people of the state of New York. Let me break it all down for you in this hot take. I got on my hot little hand the stipulation and order, and I'm going to explain it to you one place only, MeidasTouch Network. The judge first recites how we got here, that the appellate division reduced the amount of bond that was required to be posted to $175 million, that they attempted to, the Trump side attempted to post the bond on the 4th of April, that the Attorney General filed a notice of exception about the surety and asked for the court to conduct a hearing to justify the surety pursuant to certain laws of the state of New York. The judge just then went through what is going to be the collateral. Now, just give you the compare and contrast. The original bond was bad. The original bond was bad for the people of the state of New York. It was this Schwab account. It wasn't all in cash. The surety or the bonding company, Knight Specialty Insurance Company, which is owned and controlled by Don Hankey, who's a Trump supporter out of California. He's the auto repo king. He's the king of the subprime auto loan. Bad and no credit, go to Don Hankey. That's why Donald Trump went there. That account gave Donald Trump the ability to suck the money out of it on 2 days' notice. So what kind of bond was that? What kind of collateral was that? And the surety company did not agree to submit to the jurisdiction of the courts of the state of New York. So if they screwed up, in other words, they didn't pay once Donald Trump defaulted the $175 million over to the people of the state of New York and the Attorney General, then the Attorney General, under the terms of the bond, would have to sue them in Delaware or California. Ridiculous. Judge said, ridiculous. Come back to me with a better deal. And here's the better deal the judge has now signed off on. On page 2 of the order, the decision and order, it says, and this is something we didn't know, some new information here on this hot take, due to privacy and security concerns resulting from an inadvertent public disclosure of the Charles Schwab account number. So apparently when they posted the Charles Schwab account as a collateral, Knight screwed up the bonding company for Donald Trump and posted the account number. So now the parties have agreed, the judge is okay with it, that they're going to create a new government, new sweep money market fund with an account number in the name of Donald Trump bearing account number 2327. That account cannot be altered or changed without court approval. Monthly invoices, monthly statements of that account have to be provided to the judge related to the account. It has to be kept all in cash. This is all, again, improvements to what the original bond requirement or the original bond undertaking was. Alina Habba was like, well, the judge doesn't understand anything. Well, he understood enough to require that the sweep account at Charles Schwab be all in cash now, that it not be changed, that the invoices or financial services statements be provided to him, that the bonding company submit to the jurisdiction of New York court. These were all sweeteners that weren't in the original proposal. That's why this is a better deal for the people of the state of New York. The judge goes on to say, with this creation of the new account that he's now going to monitor and supervise, that he also got a representation from officers of the court, the lawyers for Donald Trump, that the balance in the account exceeds $175 million and that it's in cash. in the form of government money market funds, which is usually a sweep. A sweep account is usually excess cash that hasn't been invested in any kind of security, a bond or a stock or a mutual fund or something like that. This is like the leftover cash. It's usually kept in treasuries, in government bonds and treasuries, which are highly secure. So that's why it's a government money market fund. That's good for the people of the state of New York. And then, as the judge said, that this is the new amendments on page 3 of his order. Here's the requirements: that the funds in the existing account be swept into the new account, and that that account exceed $175 million, that it get transferred to the new account, and that it stay in that new account until the obligations under the bond are no longer in effect. Number 2, which is again an improvement from what Trump tried to get away with the first time, that the bonding company shall have, this is number 2, exclusive control over the new account. They didn't have exclusive control over the new account last time. They gave Donald Trump a 2-day head start to drain the account, Alina. Number 3, defendant shall provide plaintiff's counsel and the court in camera, meaning don't file it on the public docket, with a copy of the monthly statement by the 10th of each month that the bond remains in effect. That's an improvement. That there be no further amendments to the pledge agreement or the control agreement which underlies the bond, permitted without court approval on no less than 5 business days' notice. And finally, the bonding company, Knight Specialty Insurance Company, submitting to the jurisdiction of the New York courts so that the Attorney General and the court don't have to go chase them in Delaware or in California as alternate jurisdictions. And so it says specifically in number 5, KSIC, the bonding company, consents to submit to the jurisdiction of this court in connection with any action related to or arising under the bond or any of its related documents, waives any right to take the case to federal court, remove the case to federal court, and appoints a local registered agent, a law firm, Bressler, Amory, and Ross, which is their insurance bonding law firm down on State Street, as its agent for service of process. So they're not going to fight jurisdiction. They're not going to fight service of process, handing the complaint to them, and they're going to not take the case over to federal court. They're going to stay in state court. Again, sweeteners, improvements negotiated through the Judge Engoron, who should get a lot of credit for this. And now the people of the state of New York are secure, and it should satisfy the appellate division, First Department, which is the appellate bosses for Judge Engoron in this particular matter. What happens next? You don't just come for what happens on Legal AF. You come for what happens next. Now there's an appeal process that continues. Donald Trump has to submit the record on appeal by June. There's briefing through June, July, and August, and the oral argument on whether all or none or some of the $465 million judgment are going to be overturned or disturbed on appeal by the appellate division, First Department, is going to happen in September after the summer. They don't hold oral argument in August. Summer off in New York, at least for appellate courts, pick back up in September. And then from September, we'll have to wait on a ruling. That could be 2, 3, 4, 6 months before we get an order. There's no kind of rush here. In the meantime, the bond for $175 million stays, is not disturbed. And if after the appellate division rules, Donald Trump doesn't like the results there, he can try to take the case one more level up to the Court of Appeals in the state of New York. That's the highest level court. Most states, it's called the Supreme Court. We call our trial level court the Supreme Court in New York, and then he can try there. After all appeals are exhausted, let's say late 2025, and let's say the judgment stays as it is or close to it, Donald Trump has to pay that within 30 days. If he doesn't pay it, simultaneously, the state, through the Attorney General, can take the 175 bond, has to be paid over to them, while they continue to go after the difference between the total judgment with interest running at 9% statutory interest compounded. So let's just add another, 18% onto the judgment. Let's call it another $70 or $80 million. Now we're over $520 million minus the $175 million in bond amount. And that balance, she goes after bank accounts, real estate, any kind of exposed asset, right? Real estate, condominiums, his triplex, whatever they can get. If it's not in the name of the entity that's the judgment debtor, because he has all these other LLCs, then she'll go to try to what's called pierce the corporate veil, argue that it's an alter ego, and grab that asset. So asset grab will go on during 2025 and into 2026 until the people of the state of New York are made whole with running interest. Nothing about what I just said generally will be stayed, even if Donald Trump somehow were to make his way back into the White House, which is appearing to be ever more unlikely. He won't be able to stay the collection against him as a business person for all of these issues. And so we shouldn't have to worry about that. But that's the big picture, 5,000 square foot looking down. I think that's why you come to Legal AF and these kind of hot takes. Follow me right here. MS Popok, all things social media. If you like my hot takes, give me a thumbs up and leave a comment. And then you can go catch all of my posts, hot takes on MeidasTouch YouTube under playlists, contributors. Look for Michael Popok. Join me Wednesdays and Saturdays at 8 p.m. Eastern Time for Legal AF, that show we do at the intersection of law and politics like no other. Join us. You'll find out why we call it Legal AF. And then you can get it on audio podcast platforms of your choice. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.